There's a potentially important case there reported in the newspapers today and indeed on the other media. It's to do with the Ulster Bank losing a High Court appeal against findings by the Financial Services Ombudsman. The bank have failed to convince the High Court that the Ombudsman was or had committed serious and significant errors in his decisions. The findings of the Ombudsman were that two borrowers were entitled to tracker mortgage refunds and compensation, and that decision or those decisions could lead to the lender Ulster Bank paying compensation to thousands of similar customers before exiting the Irish market. The High Court dismissed the appeal against the two decisions by the Financial Services and Pensions Ombudsman. The bank failed to convince the High Court that the Ombudsman had made an error in his decisions. The judge was satisfied to uphold the decisions of the Financial Services Ombudsman that the bank's conduct was contrary to its contractual and consumer protection obligations. A spokeswoman for Ulster Bank, which has been in wind down here for the last couple of years, said that the UK-owned lender notes to the judgment from the High Court today and will now take some time to look at this in detail. She declined to say whether Ulster Bank are going to appeal it or not. Ulster Bank had previously said in its annual report that the outcome of the cases may have a materially adverse impact on the company. That's very significant because Ulster Bank have clearly in their accounts recognised that if this decision went against them and they didn't appeal it successfully, then thousands of borrowers could be entitled to the same compensation and so on, and entitled to tracker rates, and would have a serious impact on the balance sheet of the parent company NatWest. Counsel for the bank told the High Court last October that the cases may have an impact on thousands of customers and trigger enormous financial consequences for the lenders. The two borrowers that took their cases to the Financial Services and Pensions Ombudsman had been excluded from a redress scheme in an industry-wide examination overseen by the Central Bank between 2015 and 19, in which more than 40,000 cases of overcharging were identified across Irish lenders. Ulster Bank initially appealed over the Ombudsman's binding decisions that customers in three cases had an enduring contractual entitlement to tracker interest rates after periods on fixed rate loans. And that's the key to this case. The decision was that the customers had an enduring contractual entitlement to tracker interest rates after they had been on periods of fixed rate loans. Last October in the High Court, the judge was told the parties had agreed that one of the decisions being challenged would be set aside, with the Ombudsman to consider the matter afresh. However, orders were on hold in relation to that to allow the High Court ruling to inform directions accompanying the remittal. The appeals before the court focused primarily on one of the three cases. This case involved two borrowers who took out a mortgage in April 2004 that initially had a one-year reduced interest rate before reverting to Ulster Bank's so-called home loan rate, its standard variable product. They signed a so-called flexible mortgage transfer form in 2006, entitling them to move on to a tracker loan. They subsequently applied in May 2007, as ECB rates were rising, to fix their interest rates until August 2010. The relating loan document said the bank may offer to extend the fixed period at the end of the fixed term or offer alternative available products. However, if these were not accepted, the contract stated, the borrowers would revert to the bank's home loan rate. When the fixed rate period ended, the borrowers sought to revert to their previous tracker rate, but the bank refused as it stopped offering that rate to new customers since 2008. In her ruling, the judge said that a significant factor of the Ombudsman's analysis of the loan contract was the bank's original commitment to offering alternative available products at the end of the fixed rate period. The bank had never explained that the tracker rate might not be available when their fixed rates came to an end, she said. The Financial Services and Pensions Ombudsman was entitled to decide that the borrower's contractual entitlement to the tracker rate continued at their election, the judge said. In other words, if they chose. Whatever interest rate the borrowers were entitled to must come from the contract they had entered with the bank, she said, noting there had been no rescission of the contract when the clients switched to other interest rates. Good man, thanks. She refused the bank's appeals and affirmed the Ombudsman's decision. It will be interesting to see whether Ulster Bank appeal this further to the Court of Appeal, but that's the situation as it is. It could have serious and significant financial consequences for Ulster Bank, because they have admitted themselves openly that thousands of similar customers could be affected or are affected by this decision, and their balance sheet may well be adversely affected as a consequence. Hope you find this video useful. If you do, I'd appreciate if you give it the thumbs up down below. Thanks a lot.